The Washington State Supreme Court has ruled, this from the Spokesman Review, that the bar exam will no longer be required to become an attorney in Washington State. The central argument is that requiring people who want to practice law to take the bar exam is racist, of course, because everything's racist, and that standard, for whatever reason, is having a disproportionate impact on people of color entering the legal profession. So we had a lot of questions yesterday when we heard this about, like, how big of a deal is this? How much would it reduce the quality of attorneys, et cetera? I think there are a lot of implications to consider. So we asked our friend, our own attorney, Jackson Maynard with the Citizen Action Defense Fund, to come on and walk us through it. Jackson Maynard, welcome to Undivided.
Thank you, Brandi. Appreciate you having me on the show again.
Well, I got a question to ask you. I should have asked you this before you became my attorney. Did you pass the bar exam?
Yes, I did. I did pass the bar exam. It was 22 years ago. I remember it vividly because it was a horrible, horrible experience. But it's necessary in my mind because you need to be able to do it to be able to demonstrate your competency at the law.
Yeah. So just it sounds like an obvious question, but what is the bar exam?
So at the end of 3 years of law school, you take this exam. Every state offers it, I think, except now potentially Oregon has a separate pathway. But for years and years and years, states have had it where you take this exam at the end of your 3 years of law school, and it's over a 2-day period. Usually, different states do it a little differently, and usually it's 6 hours, so 3 hours in the morning, 3 hours in the afternoon, and it tests you on all of the different areas of law. So there's a lot of information that you have to be able to distill under very, very difficult timed conditions with hundreds of other people in a giant room where your entire ability to do your profession is depending on it. And then they also have an essay component where you read a lot of material and you have to pull out the relevant facts and be able to, in essay form, describe and be able to analyze that quickly. So it's a very difficult, stressful experience. But I do think it is important and it is necessary because, like in other professions, to those, much is given, much is required. So in medicine, there's also a stressful type of exam. If you're an airline pilot, they have different requirements as well. Law enforcement, if you go into the military, again, you have great responsibility, and they have boot camp and where you have to demonstrate competency under very intense pressure-filled conditions. And so I think that is relevant to the legal profession in being able to show that you can be competent in these different areas under very, stressful conditions, as the profession sometimes requires.
So what they're talking about now are these various pathways, and one of them sounds like kind of a glorified internship, so to speak. Do you believe that those sorts of pathways could effectively teach law students the same things that they might learn while studying for the bar exam?
Prior to there being bar exams, the tradition in this country and in England is you would read law. You would study under an apprenticeship of an attorney for a period of time. They would walk you through the text while you're working in a legal office. So there is that tradition, and I do think there is some value in sort of clerkships and experiential types of things in law school and programs. And for years, and this is noted in the task force report, the Washington State Bar Association has had a different non-law school pathway. It's called the Rule 6 program, where you could study under an attorney and then take the bar exam without having to go to law school. So they've been kind of playing with this, and I think there is some value in it. And certainly there's merit in trying to find ways to encourage lots of different groups to who could be good lawyers to practice law. I think that's a worthy goal, because certainly, some groups are underrepresented in the legal profession. And I think that's a worthy discussion of figuring out, are there barriers that don't affect the practice of law that we could look at? But in the end, I think having an exam that everybody has to take, an objective standard, everyone is forced to do and demonstrate the same knowledge in the same way to make sure that they can represent clients because we're talking about people's life, liberty, and their property. I mean, if mistakes are made, and if people are not able to have the competency to represent, there could be enormous consequences for individual clients. In the same way that if you have doctors that can't function under pressure or demonstrate their mastery of knowledge, that can have horrible implications for patients. So I think there is value in having one test, even though I think the ways that you can attain the knowledge to take the test could maybe differ.
So let's talk about the two sort of issues at play here. This had this racial component, which we'll get to round things out, but the competency component of it. I mean, I've met lawyers who did pass the bar who I didn't think were particularly good lawyers, and then there's ones like you that are just A plus, top of the line, right? So there's some discrepancy, even for those who pass the bar, right? There's some discrepancy. But let's say, I mean, first of all, practically speaking, do you think law firms will hire someone who didn't pass the bar and went through one of these other means?
I will say, just based on my experience in dealing with other lawyers, and I've had friends and relatives who have used the Rule 6 program to train lawyers and tutor folks, to take the bar exam. So they use the program. I do think within the profession, there's going to be some skepticism. And I know just from talking to the lawyers, they're a little worried about what this could do to the profession. I'm glad the Bar Association, as part of the court order, will be looking at implementing this, and I hope there will be more conversations and opportunities. But I know that there is concern within the legal community and some of the lawyers I've spoken with about the impact that this could have on the practice of law here.
My big concern and question is that clients might use this to sort of get appeals. Like if you have an attorney who didn't actually pass the bar, but found another way in, and they represent you in a criminal case and you are found guilty, do you think that could be a means to say, well, I didn't have competent counsel?
Whether or not, just based on the fact that my lawyer didn't pass the bar exam but was admitted to the law in a different way, I think that would be an interesting issue for the court since they okayed this process. It would be a little weird for them to say, oh, but lawyers that don't pass the bar aren't as good, and I think that would undermine that. That would be a little bit of a problem for them. But I think, again, to analogize it to a doctor, like would you really want to go to a doctor if the doctor didn't go to med school and just sort of like studied under another doctor for a while? I mean, they have residencies after they demonstrate certain competency in medical school, and there is a component of that for years. It's a part of the educational process, but I do have concerns about that. Sure.
Yeah. So let's talk about the racial component. I just find it to be a racist assertion that you'd have to lower standards to get people of color to be able to become attorneys. Did you go to law school with people who weren't white?
I did. And they're enjoying incredibly successful legal careers today. I think that's probably a little one of the more problematic parts of the task force report. I dug into that a little bit today, and even they admit that the data where they're trying to say, oh, the bar exam itself is racist because there's a disproportionality in the report, it indicates that the data is incomplete. They have to go back to a report from 1998, and when they talk about the history of the bar exam as sort of an element of racism or something, they're citing a Teen Vogue article, which I found a little odd. So I don't know that the scholarship underlying some of the conclusions in the report was completely fleshed out. Certainly I do think that in as I mentioned, that certain minority groups are underrepresented in the legal profession. I think there can be a lot of different reasons for that, and I think it is worthy of kind of looking into, are there barriers in place? That said, again, when you're dealing with professions that can have severe consequences with people, I do think it does make sense to have higher burdens, that you can make sure that they have the skill level to make sure that they don't harm people through mistake or lack of qualifications. And so I thought it was somewhat ironic, and this kind of ties into our conversation, that they felt like allowing more people who hadn't passed the bar would help solve the problem, for this a lack of public defenders that they're studying and looking at and kind of setting new standards. Because I think, who you want to have the best counsel if you're facing a criminal charge is somebody, the highest level of professionalism in counsel is your public defender, or someone that's representing you, where you could have your life or liberty at stake. And so the idea that, I think there's a little bit of a tension there, the idea that we would, this could be a tool to get more lawyers to people in these, in this situation where you really need to have competent counsel, by sort of watering down the standards. That troubles me a little bit.
Yeah, that doesn't seem like it makes a lot of sense. All right, Jackson. Well, thank you for explaining this to us. I'm glad you did pass the bar. I, for one, think that's a good thing and preferable. And we'll have you back on soon.
Great. Thank you, Brandi. I appreciate it.
Always appreciate it. I had to ask him, are you white? Because I was like, oh, maybe we have an attorney of color coming on to talk about this. Because I was like, I can't tell. He's got Eastern European, which apparently is white. So, but anyway. Yeah, I just don't know how to feel about it. I mean, I think that it's important, like he said, in the medical field and, policing, you have all these standards for people to make sure individuals are taken care of and that they don't hurt somebody. And I mean, there are few situations in your life that you need someone as competent as when you're standing before a judge and like your freedom's on the line. So the fact that this is sort of a hope to fill the ranks of public defenders, don't you already complain that people of color are disproportionately in need of public defenders? So now you're going to give them the attorneys who are likely least qualified to be in a court of law? Doesn't that seem counterintuitive to you?